Good day, class. Welcome to CLJ 3 or Criminal Law Book 1. And today I'll be discussing reading material number 3. So, Article 3 definitions. So, acts and omissions punishable by law are felonies. What are examples of criminal acts and omissions punishable by the revised penal code? So, number 1 is murder. Second, theft. Abortion, either intentional or unintentional, robbery, qualified piracy, treason, etc. Okay, and omissions punishable by the revised penal code. Example: if you found a lost property and you fail to deliver it to the proper authorities, you will be held liable for theft. And also, um, if ever makaligis ka tao and you fail to lend help, ni imo na siyang gi-abandon imong victim. Okay? Therefore, you will be held liable for reckless imprudence resulting to serious physical injuries or homicide as the case may be. Okay, that would depend if the victim dies. And also, it will aggravate your penalty because you abandoned your victim. Okay, so that's an omission. And you will be held liable under the revised penal code. That's why felonies are acts and omissions punishable by law or the revised penal code. Okay, so felonies or delitos. Second, felonies are committed not only by means of deceit or dolo, but also by means of fault or culpa. So deceit means the criminal act is performed with deliberate intent, like murder. There's evident premeditation. There's intent to kill in murder, and also in stealing. Okay, in the crime of theft, there's an intent to gain. Okay, or intent to steal, and there is fault or culpa when the wrongful acts result from imprudence, negligence, lack of foresight, or lack of skills. So usually, sa mga crimes din siya sa reckless imprudence resulting to homicide, reckless imprudence resulting to physical injuries, reckless imprudence resulting to damage to properties. Okay, can fault or culpa. So next, felonies. What are felonies? So felonies are acts or omissions punishable by the what? RPC or the revised penal code by definition under Article 3. So when the law says by law, it means, of course, the revised penal code. Okay. So remember that crime is a general term, while felonies, offenses, or infractions are specific terms. So felonies are acts and omissions punishable by the revised penal code. Offenses are acts or omissions punishable by the special penal laws, while infractions are acts and omissions punishable by ordinances. So what are acts or word acts? So acts refers to the body movement of a person which has a direct connection to the felony intended to commit. So it refers to the external act or overt act. Overt act meaning the act or the criminal act is in connection with the felony intended to be committed. For example, in stealing, so may overt act of stealing or theft. Just to say, sulod sa mall, mangawat ka. Of course, pag abri sa mga drawer, sa jewelry section, okay, then kwaon. Okay, that's overt act. Okay, in murder, okay, pointing a gun at someone, that's an overt act of murder, killing a person. Okay, as long as ang imong acts nga buhaton is in connection with the felony intended to be committed. Okay? Example, ano, how about internal acts? Is it punishable or mere criminal thoughts? So internal acts or mere criminal thoughts will never give rise to a crime. Mga internal acts lang. Example, A lust for his neighbor. Whenever the neighbor would pass by going to work, A would always look at the neighbor. And for the whole day, you would think of the neighbor with nothing but lust. Ulag. Okay, so no matter how criminal his thoughts are, it will never give rise to a crime. because it is merely internal. Okay? So wala may overt acts nga nang rape siya or nag-commit acts of lasciviousness. Again, nullum crimen nulla pena sine lehi. There is no crime if there is no law punishing it. So if naguna-una pa lang gagtuan, mo siyang ripon or commit mga acts of lasciviousness niya, like labot niya yung boobs, buttocks, etc. Dili pa na siya punishable because the law requires an external act or an overt act. Overt act gani meaning an act related to the acts or the felony intended to be committed, like acts of lasciviousness or attempted rape. The law requires acts in order for a person to be held criminally liable under the revised penal code. Omission. So omission meaning the failure to perform an act or to do a duty which is required by law. So example, so if a person found any personal property on the street or any place and failed to deliver the same to the owner or to the local authorities, he becomes liable for theft under the revised penal code. And second, if a person was driving his vehicle, then he bumped and hit another person. And instead of helping that person, he increased his speed and left. So there's a hit and run situation. So such fact that he failed to lend help and assistance to the victim will what? Aggravate his criminal liability. Okay, because he abandoned his victim. He failed to lend help. Therefore, it will aggravate his criminal liability. Two kinds of felonies. What are the two kinds of felonies committed under Article 3? So we have deceit or dolo and fault or culpa. So deceit, what is deceit? So deceit or dolo is called an intentional felony because when you commit dolo, when you commit an intentional felony, there's deliberate intent. Okay, so intentional felony exists when the act is done with deliberate intent. So we have here three elements for it to be considered as a deceit for dolo or intentional felony. Number one, there should be criminal intent on the part of the offender. Criminal intent, intent to kill, intent to gain. Okay, freedom of action in doing the act on the part of the offender. Okay, he is na siya free will to do the act. He has freedom of action. Wala ni sugo niya. Wala ni pugos niya to commit the crime. Freedom. He is free. Okay, to perform an act. And intelligence of the offender. He must not be insane. Dapat dili siya insane. Dapat dili siya imbecile. Dapat dili siya minor below 15 years old. Otherwise, that's exempting circumstances. He will be exempted from criminal liability. So take note that an intentional felony is voluntary, of course, because there's freedom of action and intelligence on the part of the offender. And yes, it is a voluntary act because it is committed by means of deliberate intent. Okay, you should take note of that. Fault or culpa. So what do you mean by fault or culpa? So this pertains to what? Culpable felonies, like mga reckless imprudence cases. Okay, so it exists even when the wrongful acts results from imprudence, negligence, lack of foresight, or skill. So what are the elements? So negligence, of course, criminal negligence. And then number two, freedom of action. And third, intelligence. So freedom of action meaning ang offender wala siya gisugo o gligis sa usa ka tawo. He is free to do o unsa man iyang ganahang buhaton sa pag-drive. Wala namugos niya, wala ni force niya ang ligson ng usa ka tawo. And intelligence, of course, he is sane, not insane. Okay, so under Article 365 of the Revised Penal Code, culpable felony is defined as one wherein the offender, although without malice or deliberate intent, cause an injury to another by means of what? Negligence or imprudence. Therefore, a culpable felony is a voluntary act because what? The accused has freedom of action and intelligence. The only problem is na negligence involved. That's why culpable felony is also a voluntary act. Okay. And also, it is punishable under Article 365, the Revised Penal Code. So let's discuss voluntariness. So insofar as criminal law is concerned, voluntariness is actually the concurrence of three elements of intentional felony and the concurrence of the three elements of the culpable felony. So meaning complete elements like criminal negligence, freedom of action, intelligence, in fault or culpa, or in deceit, dapat na ay criminal intent, freedom of action, and intelligence, involuntariness. So in other words, insofar as voluntariness of intentional felony is concerned, it is the concurrence of criminal intent, freedom of action, and intelligence. So therefore, if without voluntariness, there can neither be intentional felony nor a felony. Okay? So next is freedom of action. The freedom of action means that the offender performs an act on his own free will. Okay? Wala siya gi-force, wala duress, wala uncontrollable fear. Okay? The act is done on his own free will. He has freedom of action to do what he wants to do. So if the offender performs a criminal act, but he did not act because there was this compulsion and irresistible fear or under the impulse of uncontrollable fear, there is no criminal liability. Before siya to kill a person. Otherwise, if you not do so, he will be killed on the spot. Okay? So there is no criminal liability. They are exempting circumstances under the revised penal code because there's no freedom of action. Gi-force man siya to commit a crime because if he will not do so, he will be killed. So, murag si accused, nahimo siya mere instrument, okay, sa crime. Kaya wala siya freedom of action, napusan na siya commit ato. Otherwise, he will be killed. Okay? So, there is neither an intentional felony nor culpable felony because there is one thing of freedom of action, an element of voluntariness. Intelligence, so the mental capacity of a person to know what is right or wrong and to appreciate the consequences of his acts. So if he will commit a crime, kabalo siya nga na a corresponding punishment. So if a person acted without intelligence, there is no criminal liability. Exempting circumstances, yan po ni siya. So if the criminal act has been committed by an insane, okay, insane, buang, an imbecile, or a minor below 15 years old, the said offender is exempted from criminal liability under the revised penal code because they lack intelligence. Okay, so under Article 12, they are exempting circumstances. The offender is free from both intentional and culpable felony because he acted without intelligence, which is an element of voluntariness. So intent. So it's the use of particular means to achieve the desired result. And you can see intent. It is an internal state of mind. So we have here the factors to determine intent. So in the case of Rivera versus People, the court declared that the evidence to prove intent to kill in crimes against persons like murder or homicide may consist of the following: the means used by the malefactors, whether gun ba na siya, knife, batuta, etc., stick, and the nature, location, and number of wounds sustained by the victim. Kadagan ba na siya gidunggab? So if kadagan gidunggab, meaning there's intent to kill. Kadagan man gidunggab, kisa pa mabuhi o dagan ang sustain, kisa mabuhi pa ba ang victim if nakasustain siya multiple stab wounds, di ba, no? The location, maybe tapit sa heart, okay, sa neck, okay, mga mortal wounds and inflict sa offender, sa victim. Okay? It would prove intent to kill. The conduct of the malefactors before, during, or immediately after killing the victim. Nagbunyi ba sila after killing the victim? Nakitaan ba sila nga resulting ang patyo nila si Juan de la Cruz? So before killing the victim, na nakita nila nga eyewitness, nagsabot sila nga patyo nila si accused. Okay? So during, nakakita nila nga sila may kapatay. Then immediately after killing the victim, nagbunyi ba sila nga yes, napatay na ako si Juan de la Cruz, etc. Napatay na namo. Nga na. Okay, so the conduct of the male factors. And number 4, the circumstances under which the crime is committed and the motives of the accused. So, very important factors to determine criminal intent. Okay, so example, this is say A was walking, then here comes B with a lead pipe and hit the head of A with it. B hit it hard and thereafter ran away. A went to the hospital. However, based on the medical certificate, no injury whatsoever was sustained by the head of A. So there was no injury. Nevertheless, A filed a case for attempted homicide against B. Therefore, intent to kill is incumbent to be proven by the prosecution because the case filed is attempted homicide. So it's up for the prosecution to prove the case of attempted homicide. Okay? So factors to determine intent, continuation. Now, in the example, will B be given, will B be held liable for attempted homicide? Was there intent to kill in the situation? So the answer is no. There was no intent to kill. So let us apply in this case the factors to determine whether intent is present. So was there motive? Okay? The answer is no. In the problem, there was no motive to kill A. Therefore, B should not be held liable for homicide. What was the nature and number of what was used? Diba only lead by para may i-use ni B? Now, nya kasara po niyang gibunalan si A. Then ni sibat. Okay? Was there intent to kill? The answer is no. Okay? Unless if kadagan niyang gibunalan siguro. Okay? Of course, it will create in our minds that B really had intent to kill. Okay? And last question, what is the nature, number, and location of wound inflicted on the victim, Mr. A? So the victim did not sustain any wound, remember? Okay? Ningon si Dr. Dere na medical certificate, no injury was sustained by the hand. So probably, gihine ra to siya igo, okay, with a lead pipe sa ulo. Okay? Gihine ra si A, igo, lead pipe sa ulo. Then, italagan ra si B. So, atong ibalik to ang kuan, factors to determine intent, the means use of the male factor is the lead pipe, the nature, number, and location of wounds of the victim. So according to the doctor, no wounds. Okay? And the conduct of the male factors, diba, before, wala, during, but immediately after killing the victim, immediately after the commission of the crime, is Batra. Okay? So based on the foregoing facts, there's no intent to kill, but only slight physical injuries. Okay? So, what was the manner of committing the crime? So, after hitting A, manner niya, about the manner of committing the crime. B ran away. So, if he had intended to kill the victim, Mr. A, he would have hit A several times in the head. May example, kas araman niyang gihit, then he ran away. Wala gani kuan. Nakasustain of wounds to iyang first hit. What were the act, deeds, and words made by the offender before, during, or after the commission of the crime? So he just saw the victim, okay? Then hit the victim, and then run away. All of these would show there was no intent to kill on the part of the said offender. Therefore, B should not be convicted of attempted homicide. So example, okay. So the use of a lethal weapon would show intent to kill on the part of the offender, although death did not arise. Okay, as long as you will use a lethal weapon, such as a gun, it would show that there's intent to kill on the part of the offender. Okay, and then taking personal property of another without the consent of the owner would show intent to gain on the part of the offender. Like, imong gikuha ang cellphone sa imong classmate without your classmate's consent. Okay, it is presumed that there's intent to gain in your part. Okay, even if imo nang i-return, the crime of theft is already consummated. Because ang elements sa crime of theft is what? Taking of personal property belonging to another with intent to gain. Okay, and without violence against or intimidation against persons. So if all elements is complete or are complete, meaning you committed a crime of theft. It doesn't matter if imong i-retard na abutang. Okay, crime of theft is already consummated. We have here two kinds of intent: general criminal intent and the specific criminal intent, the GCI or the SCI. So, what do you mean by general criminal intent? So, general criminal intent is conclusively presumed by law by the mere doing of an act, and the prosecution does not have the burden to prove it. This is say, for example, namatay ang usa ka tawo. Okay? So, there's butang na to nga si accused. There's a criminal intent to kill the victim. Okay? Because namatay naman ang victim. So, it is presumed nga si accused na i-intent to kill. As long as namatay na si accused, it is conclusively presumed by law. Okay? Nga na siya criminal intent to kill the victim. Okay? So, the prosecution does not have the burden to prove nga si accused may gapatay. Si accused mo'y na ay burden of proof nga maybe he acted out of self-defense, etc. or by mere accident. Kaya na, accident niya itong napatay. That's why exempted siya from any criminal liability. Okay? So we have here specific criminal intent. So specific criminal intent is just like an element or an ingredient of the commission of the crime. Therefore, it must be proven by the prosecution beyond reasonable doubt. Okay? So let's just say sa katawang nagkulata and the victim filed a case of murder. However, serious physical injuries around that case. So the prosecution must prove beyond reasonable doubt that the accused in hitting the victim has criminal intent to kill such victim. So pala noon, ay mo siyang element. So ang intent to kill will become an element now. Okay? Sa crime. Because if ma-prove ni, dili serious physical injuries ang case na, mahimo na siyang attempted murder or frustrated murder. Okay? So, example. So, intent to kill must be proven in frustrated or attempted homicide or murder. So, example, A and B were fighting. A was losing and so A shot B. B was hit on the left arm. He was brought to the hospital. Thereafter, after B's release from the hospital, he filed a case for attempted homicide. Since the case filed is attempted homicide, the prosecution has the burden of proving intent to kill on the part of A when he shot B and hit him on the left arm. So otherwise, if the prosecution failed to prove intent to kill on the part of A, then A can only be convicted of serious, less serious, or slight physical injuries, okay, depending on the date required for medical intervention. Or otherwise, he should be acquitted of the crime. So, intent to kill must be proven first, okay? Next. But what if in the course of their fight, A was losing and so A took out his pistol and he shot B. B was shot on the heart. That's a fatal wound, okay? A mortal wound. So, a mortal wound was sustained because it was a vital organ which was hit. A immediately brought B to the hospital. However, upon arrival, he was pronounced dead. So therefore, the heirs of B filed a case of homicide against A. His defense, I have no intention to kill. B. So according to him, he only intended to threaten B because they were fighting. So will A's defense stand in court? The answer is no. Why? Because A's defense that he has not he has no intent to kill B will not lie. The reason is since the victim died, therefore nanatay general criminal intent. in which dili ang prosecution mo prove sa general criminal intent but the accused, the defense counsel of the accused. So intent to kill becomes a general criminal intent which is presumed by law. Eh namatay naman ang victim. So it is presumed. So the prosecution will not prove intent to kill in homicide, parricide, murder, infanticide because the victim died. So it is only in the attempted or frustrated stages of the crime wherein intent to kill is considered an element. So there's attempted homicide or attempted murder. So ang criminal intent kailangan i-prove sa prosecution. Otherwise, if he failed to prove that there's criminal intent to kill, crime is downgrade into serious physical injuries, less serious, or slight physical injuries depending on the time of medical intervention. Okay, used. So if there's a consummated crime of homicide or murder, it is presumable that the accused has intent to kill the victim. So why is it only in the consummated stage of homicide, parricide, murder, infanticide that intent to kill is presumed? Because yes, the best evidence to prove intent to kill is that the victim died. Therefore, it is presumed by law na. Okay? So is there a defense to negate criminal intent? If wala siya intent to commit the crime. Of course, the accused may plead mistake of fact. Um, mistake of fact meaning there's a misapprehension of facts. Let's just say the accused thought that uh, the victim na intent to kill niya, like patyon siya. Let's just say, for example, nasusulod sa iyang house and then ay usa ka tawo nga nagsigig open si ang balay and he thought that person is a friend. So in defense, pag open sa door, iyang gistab ang would-be robber. However, roommate ra dayto niya. So there was misapprehension of facts. He thought niya robber to. So he acted in self-defense. Therefore, wala siya criminal intent to kill the victim. Therefore, absolved siya from any criminal liability because of mistake of fact. Okay, so that's mistake of fact. Misapprehension of motive. What is motive? It is the moving power which impels a person to do an act to achieve the desired result. So, as a general rule, motive is not material in determining the criminal liability of the offender. When the offender is what? Identified. Nailahan na ang offender, so no need to prove motive. And when the offender or the accused admits to the commission of crime, or if the prosecution has direct evidence or eyewitness, direct evidence meaning nakuhaan sa CCTV footage nga si accused muy nangawat or nagpatay ng victim or eyewitness, okay, during the commission of the crime na nakakita the accused in killing the victim, okay, and crime committed is not a special penal code but under the RPC, revised penal code. So we have here exemptions. So motive becomes material in determining the criminal liability of the offender when the act of the offender would result to variant crimes. Okay, dua ka crimes, variant. There's variant. So what's the purpose of determining motive? Of course, to know what crime should be charged to the offender or the accused. Okay? So second, when the identity of the offender is doubtful. Okay? And third, when the prosecution only has circumstantial evidence to prove the commission of the crime, not direct evidence or eyewitness testimony, but only circumstantial evidence. Okay? So motive becomes material if present ng mga exceptions. So example, city mayor was jogging near the seashore. And here comes X who went to city mayor, and the city mayor was not in the performance of his official duty when he was shot. Therefore, the act of X in killing and shooting city mayor may result to variant crimes, two or more crimes, depending on the motive, depending on the reason of acts of killing the city mayor. So if the reason is a personal grudge lang, so murder is committed because there's premeditation and there's treachery. Okay? Yung ito sila. Okay? There's treachery because the city mayor was not in the position to do it. So, and of course, I think it's planned. Okay? So there's evident premeditation. But if the reason if is because of the city mayor's past performance of his duty, then the crime committed is direct assault na. If in connection with the city mayor's performance of his official duties. So, instead of plain murder lang, may siya direct assault with homicide or murder. Okay, as the case may be. So it will result to violent crimes. Therefore, motive is important. So motive, examples of motive. Personal grudge. Gilago na siyang mayor. Na siya vendetta. So, if ever if si X yung partner si mayor, murder na ang yung na-commit. However, if naglagot si X sa past performance sa city mayor, na siya'y kalagutan nga inagipasa nga ordinance, etc. sa city mayor. As long as in relation to his performance of official duty, then higipasa sa city mayor. So the crime is direct assault with homicide or murder na. Okay, so motive is very important. So let's just say another example. There are so many suspects, see A, B, C, D, and E, and there's doubt as to who among them committed the crime. So therefore, motive will become material in determining the criminal liability of the offender because doubtful man, I can say doubtful sila sa identity sa offender. Okay, dagan man suspects. Okay? Therefore, motive is important in this case. Another example. Okay, let's get that. How do you prove motive? So motive is proved by the testimony of the witnesses as to the acts or statements made by the accused before or immediately after the commission of the crime. So example, before killing A, an eyewitness saw B threatening to kill A. He threatened niya to kill A. And thereafter, B would have the motive because it was prior to the commission of the crime. So, or right after the killing of A witnessed or saw B running away from the scene of the crime, laughing, saying, "Finally, I have my revenge." Therefore, there is motive. That's how you prove. That's how you prove motive before or immediately after the commission of the crime. Again, testimony of the witnesses as to the acts or statements meaning gisulti sa accused or acts or criminal acts nga gibuhat sa accused like threatening to kill. So before or immediately after the commission. So that's how you prove motive. So here, motive is established by the acts or statements made by the accused prior to or after the commission of the crime, but not during. Because in motive, there is no direct evidence. Okay? So the witness did not see how the crime is committed. So that's why before or immediately after, not during. So mistake of fact. So this pertains to is apprehension of facts on the person who caused the injury to another. So if a person acted under mistake of fact, he is absolved from criminal liability because he acted without criminal intent. That is, had the facts been as he believed them to be, his acts done would have been lawful and justifiable. Just like my example, okay, a while ago. the victim or no, the accused thought nga an na imo attempt og rob sa iyang home. So baling natuyuan siya kisig abri-abri sa pultahan. So thereafter pag abri, he thought nga robber na and then patyon siya. Therefore iyang giunahan. Okay? So that's self-defense. So, and after that, later he found out that the victim kato iyang gipatay was his friend. Okay? Kasi gi-joke ra dahi siya nga adlokon giprank nga naay mga rag nga na dunyang mapatay. So there's mistake of fact, misapprehension of facts law. Kay if tinuod tong robber to nga iyang gipatay, he will be absolved of criminal liability. Why? Because he acted out in self-defense. Okay? But prank ra dahi ito. So that's why there's mistake of fact. Therefore, absolved siya from criminal liability. So elements of mistake of fact. So number one, the act done would have been lawful and justifiable had the facts been what the accused believed them to be. Had it been as he believed, the act performed would have amounted to justifying or exempting circumstances. Okay? Just like my example a while ago. And that the intention of the accused in doing the act must be lawful. That the act must be ignited by a noble or lawful intent. Okay? The third, that the mistake must be without fault, negligence, careless on the part of the offender. So the offender cannot be negligent in ascertaining the true facts of the case and at the same time invoke mistake of fact. So question, can a mistake of fact be used as a defense against culpable felony? The answer is no. Because one of the elements of mistake of fact is that intent must be lawful, not negligent. Okay? So since intent is not an element in culpable felonies, then mistake of fact cannot be used as a defense. Okay? Example, let's skip this. Can a crime be committed without criminal intent? The answer is yes. There are two instances wherein intent is not an essential element of the crime. Number one is culpable felony, fault or culpa, and when the crime is in violation of special penal laws, acts mala prohibita. So what are acts mala prohibita? So acts mala prohibita are acts which are only wrong because there is a law that prohibits and penalizes it. So examples of mala prohibita: illegal possession of unlicensed firearms, illegal possessions of dangerous drugs. As long as mga RA ng punish, acts mala prohibita na. Okay? Because they are only wrong because there is a law that prohibits and penalizes it. They are not inherently wrong. Like mga Republic Acts, Republic Act 962, Republic Act, not 962, but 9165 or the Comprehensive Dangerous Drugs Act of 2000. Then we have here acts malainse. Acts malainse are acts which are inherently evil or wrong per se. Okay, so what are examples of acts malainse? Killing another, like murder, homicide, parricide, infanticide, and taking the thing of another, like theft or robbery. Robbery, if the taking was done with violence against or intimidation of persons. So usually, ang revised penal code, ang mga crimes nga gi-define dara sa book ko is called acts malainse. Okay, generally acts malainse because all of those crimes enumerated or defined and punished under the revised penal code are inherently evil or wrong per se. And most of the crimes punished by special penal laws are considered acts mala prohibita because some of them are not inherently wrong. Okay, they are only wrong or they are only considered a crime because there is a law that prohibits and penalizes it. Okay, so yes, acts malainse versus acts mala prohibita. So, inherently evil. So, acts mala inse like murder is inherently evil or wrong in its self. So, criminal liability is based on the intent of the offender. And good faith or lack of criminal intent is a valid defense. Let's just say, in killing another person, uh, the person acted through self-defense. So there's no criminal intent to kill or mistake of fact. Okay. So good faith or lack of criminal intent may be a valid defense. So pwede kang mo-raise of justifying circumstances like self-defense or mistake of fact. And then, natay gitawag ang modifying circumstances sa acts malahinse. So, pwede mitigating or aggravating circumstances are considered by the court in the imposition of penalty. So, na yung modifying circumstances. So, if the crime is committed with cruelty or ignominy, aggravating circumstances. Mitigating, meaning there's an incomplete justifying circumstances. So, mitigating crime. And then, degree of participation of the offender na tagitawag nga principal, accomplice, or accessory. Okay? And stages of the commission of the crime. We have attempted stage, frustrated stage, and consummated stage. Okay? And acts mala prohibita, not inherently evil or wrong. And criminal liability is based on the mere doing of the prohibited act. And in this case, good faith or lack of criminal intent is not a valid defense. So once makaviolate ka of special penal laws, okay, or acts mala prohibita, dili na ka maka-invoke of good faith or lack of criminal intent. Okay? So that's very important to know. And last, the only stage considered is the consummated stage. Walay attempted or frustrated stage sa mga acts mala prohibita under special penal laws. However, unless, okay, nag-provide ang special penal laws of attempted or frustrated stage. So usually, Section 5 o 11, okay, consummated. Ano wala, attempted, Section 5 o Section 11 sa RA na 165. Okay? Selling or possession of dangerous drugs. Automatic na siya consummated. But you should take note that not all acts punishable by special penal laws are acts mala prohibita. There are some special penal laws which punish acts mala inse, such as plunder. Okay? Plunder, okay, is a special penal law. Yet the SC or the Supreme Court said that plunder is malum inse. They are evil in their nature. Corruption ba? Plunder. If ever ang government official makapangawat siya o at least 50 million pesos, it's plunder. Okay? So, criminal intent matters in this case, even of acts mala inse. Acts mala prohibita ang plunder. Okay? It's punished under a special law. It's considered as a mala inse because plunder is evil in its nature. Okay. So, thank you very much for listening. Please stay tuned for part 4. God bless.